Hi, my name is Cindy Gallardo. I want to tell you a little bit about Vincent Davis and his associates and how they've helped me in my situation. I was made false allegations by my daughter. A couple days later, CPS came and took my kids. My husband and I went to Mr. Davis's office. Again, the reassurance and just calming us down, letting us know that everything was okay and just telling us what our next Mr. Davis has given his personal number to contact him, and he gets back to you right away. There's no other attorney that I feel has done that.
Good morning, Miss G. How are you?
I'm good. How are you? Good morning.
Good morning. This is Attorney Vince Davis, and this is my office hours. Today, we're going to be, I guess you have some more questions for me, Miss G?
I do,
We're
actually.
going through some questions. We have to end at approximately 7:59 sharp. 6:59 sharp. I have to go to court this morning. So why don't you go ahead and start with your questions?
Okay. How parents lose their rights without even knowing? Like they lose their rights, but they didn't even know, and they're still doing classes.
The only way they can lose their rights is if they quit going to court or quit talking to their attorney. That's the only way they could lose their rights without knowing.
Oh, really?
Mhm.
Okay. But what about the parents that lost their rights? They didn't know they lost their rights, and then they were forced to continue to do classes.
I've never heard of that before.
I have a parent that lost her rights. And she's
Because
still.
when you lose, before you even lose your rights, you lose your reunification services, where the social worker in the county stop paying for your services. So if you are forced to continue to do services, the county's not paying for it anymore. You must be paying for it out of your pocket. And you must be under the misunderstanding that you have a good chance of getting the children back at that point.
Okay. And how do they accidentally give up their rights?
Accidentally, that can't
Mhm.
happen. It can't be done accidentally. There could be done by some misunderstanding. Sometimes I talk to people and I explain something to someone and they hear me, they understand me, but they don't like what I'm saying and they choose not to believe me.
Okay.
And then that rolls around, in their mind, and I speak to them a week later, and what I said to them is completely out of their mind. They've completely turned it around or forgotten it or chosen to forget it. The mind is a tricky thing. And sometimes when you're focused on something so intently, you believe what you want to believe and you don't hear what people are telling you. Like, I believe that in a lot of cases at the disposition hearing, if you lose the disposition hearing and the children are placed out of your care, and the judge gives you that warning, if you don't get your children back within a certain amount of time, your children can be permanently placed out of your care, including your children being adopted out. I don't think in a lot of cases that actually hits the parent, and the parent actually understands what the judge is saying. Or they don't understand what that means. Your child will be adopted out. They have no idea what that really means.
But how do parents accidentally give up their rights without realizing it, though?
They can't. They can't give up their rights. The reason why I say they can't is their rights are taken from them. Parents don't give up their rights. The rights are taken from them, and usually involuntarily. A few times, very, very rare, a parent will agree to have his or her rights taken from them, That's very rare. In all of the other cases, 99.99% of the time, parents' rights are taken from them. Now, unfortunately, some parents don't realize that. And in most cases, some parents don't realize how to stop it. And how to stop it starts at the very first hearing. What happens at the very first hearing, the furthest thing from your mind is that you're going to lose your children permanently. That's
Yeah.
the furthest thing from your mind, mainly because you believe that that's impossible. It is America. Justice will prevail. And look, we don't take kids away from parents. That just doesn't happen in America. I don't know if I've ever told you the story, but I told this to a client the other day. When I first heard about juvenile dependency cases, an attorney told me, he said, I'm going to practice juvenile dependency. And I said, what is that? He says, oh, that's where they take away children from parents. And I looked at him and I said, well, that's impossible. I said, this is America. That would be unconstitutional, Mike. And he kind of chuckled at me like, you silly boy, you don't know what you're talking about. He says, do you ever notice in the codes, and back then everything was, in books, there was no internet.
Mm-hmm.
Did you ever look at the codes and the code annotated, and at the end there's something called the Welfare and Institutions Code, and it's
Mm-hmm.
like 4 or 5 volumes? I said, yeah, but I never looked at it because the type of law I practice, I didn't know what that was. I had no reason to know what that was. I usually use the civil code, the code of civil procedure, the evidence code, that type of thing. So there was a whole body of law that I didn't know about. And in the Welfare and Institutions Code, and like codes around the country, it gives the state the power to take your children away from you permanently. And people just don't believe it. I didn't believe it, and I was a lawyer. Imagine what people think that aren't even lawyers. I wonder, does anybody read lips? Can anybody tell me what Miss G is saying?
Oh, I'm sorry. I said those people think the system works. That's what it that's what it is. Okay, I have another question for you. What exactly is the 6-month review hearing in the CPS case? People still, they read your book, but they still have problem understanding the 6-month review hearing. It's complicated.
Well, after the disposition hearing, the case has to be reviewed by law every 6 months. So there's a 6-month review hearing, there's a 12-month review hearing, there's an 18-month review hearing in a lot of cases, and then there's a 24-month review hearing in very rare cases.
Mm-hmm.
And those cases are just for the court to review your progress in the case plan that the judge ordered, and to see if your progress is sufficient enough for there to be another 6-month review hearing. If your progress isn't sufficient enough, the judge can stop the 6-month review train and put you on the permanent plan train, which is within 120 days, they'll pick a permanent plan. And most likely it would be the termination of your parental rights and the adoption of your children.
Why is this hearing considered a critical turning point in most CPS cases?
Because you're at the 6-month hearing, you're probably either going to get your children back, or you're going to go to the permanent plan train, and there's a possibility that you're going to lose your parental rights. So it's critical. It's critical that you either get your children back or show the judge you're close enough that you should get another 6 months. You should get another 6 months of family reunification services.
So is this like a full trial or, something else?
It should be. If you're going to disagree with the worker, it should be a full trial. Where you call witnesses, you submit documents, that type of thing. You cross-examine the social worker.
So even if the court-appointed attorneys tell them if they go to trial, they're going to lose?
Yeah. Because once you have a trial and you lose, you can appeal a 6-month hearing.
Okay.
If you submit on the report, you can't necessarily appeal. You might be able to, but you don't have any evidence.
Wow, that's so sad. What is the court actually looking for at this stage of the case, of the 6 month stage of the case? What is it that
Subs-
the court?
Substantial compliance with the case plan ordered at the disposition hearing.
And that's what their attorney has to submit.
No, that's what the parent should have submitted to the social worker during that 6-month period.
And do you recommend the parents to email them instead of meeting them? Or because I feel like oftentimes a lot of parents say, Georgette, I already gave her the report, but she told the court she doesn't have it.
Absolutely. You know, I've done several videos. We've probably done several shows. One of my seminars that I did, I laid out a plan of how you present that information to the social worker. And it involves emails. It involves weekly reports. It involves weekly summaries sent to the social worker so that he or she can't say, oh, you know, Vince didn't finish the case plan. But this is what usually is said. Vince finished the case plan, but he didn't get anything out of it. Vince took the parenting, but he just sat there like a bump on the log and he didn't learn anything. Vince physically went to counseling, but he didn't get anything out of it. He didn't internalize it. It was like he wasn't even there. So that's what you have to prove. It's, you know, a lot of times social workers will say, oh, Vince didn't go, when I really didn't go, right? That's the easy way. But the hard way, if they don't want me to get the kid back, they'll say, oh, Vince went to every counseling class or every counseling session. But you know what? Vince didn't learn anything from those counseling sessions. And why I say that is because I talked to his counselor, who said the counselor said he didn't do very well in the counseling sessions.
They lie about that too, you know that, right? They lie about what the counselors say.
That's a possibility. But if you follow the plan that I laid out in my seminar, you get around that. You have a roadmap with every stop on the way that you're documenting everything. Then it becomes hard to prove for the social worker to prove. You know, there's a case that's up north, and it's actually on calendar today for a progress report. And we filed a 388, and I think it's over 200 pages. I forget the exact number of pages, but it's a pretty substantial 388. And it was so thorough. The client had done so much work and documented so much that it forced the social worker, a few days after we filed it and served it, to recommend that the parent have unmonitored visits. Just the filing of that document. See, when you have everything documented and the social worker still is recommending things against you, they kind of lose credibility with the judge. If you don't document these things, you have nothing to show the judge. So who's the judge going to believe? The social worker. So you have to document things.
What about
document often?
What about subpoenaing the so-called therapist that said all that to the social worker?
Yeah, you can. But, you know, listen, you've been going to therapy for 6 months. You bring in the therapist to testify about 6 months worth of stuff, you know, and you maybe have 30, 45 minutes with the therapist on the stand to talk about 6 months. What's better, that or showing the therapist 24 emails where you summarized every week what you learned from therapy that you sent to the social worker and CC'd to the therapist?
Oh, got it. Okay. That makes better sense. Yeah, obviously.
And you told them what you learned, the top 3 things you learned that week in therapy, and how you've implemented it in your life. The social worker is going to be hard pressed to say you didn't learn anything. And the social worker is going to be hard pressed to say you didn't get anything out of it.
That makes
but if you don't do anything and you just bring them in and they say, well, in 24 weeks, Vince didn't learn anything,
Mhm.
How are you going to disprove that? You have nothing to disprove that. You get it?
Yeah, I get it.
So you have created your own roadmap,
Mm-hmm.
24 weeks worth. It's going to be hard for them to say, well, you know what? I don't agree with those 24 weeks. Well, 24 memos. Well, you never said anything. Every week I sent you those, and you never said a word to me about those memos being incorrect. Then who looks like the fool? The therapist and the social worker, not you. But if you don't have those 24 weeks of memos, you look like the fool. Because, the first thing the judge is going to say to you is, hey, Vince, what'd you learn in counseling? There you are trying to remember what you learned in 24 weeks. What'd you learn in week 1? I don't know. I can't remember. But if you have it written down, well, let me refer to my week 1 memo.
Mm-hmm.
In week 1, I learned blah, 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 blah. And this is how I implemented it in my life, blah, 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 blah. Do you see what I'm talking about, Miss G?
It actually makes a whole, obviously you're the attorney, but that's pretty good. Yes, I do
Yeah,
understand.
that seminar that I gave on reunification and how to win your 6-month hearing,
Mm-hmm.
I don't think you were there that day.
No,
It was on a Saturday.
Mm-hmm.
And I have to tell you, it was probably one of the best seminars I ever gave.
Yeah.
Because the woman who was the client actually had she wasn't a client, she was a seminar attendee. She had that problem. She was coming up to the 6-month hearing. She lost her 6-month hearing, and she wanted to know what she could do at the next 6-month hearing, the 12-month hearing, to win. And I told her this and other things, and I could see in her face how the light went on. And it was like, oh yeah, oh my God, I can see that. Well, months later, she sends me an email and she says, Mr. Davis, it worked. I provided them irrefutable evidence that they couldn't say that I didn't attend. They couldn't say I didn't get anything out of it.
That's pretty good, Vincent. I never knew that. I honestly,
So the emails go to the therapist, the emails
Right.
goes to the social worker and your attorney, right? So everybody has a copy.
Oh, because Erica was saying, what if I guess she meant the social worker, deletes the emails, but how? I guess
Emails last forever in the
forever. Yeah.
digital format. And
Mhm.
if the therapist, the social worker, and the attorney all have copies, it's going to be pretty hard for the social worker to say, "Oh, I didn't get that."
That is exactly it.
I don't know if you know this, but you could subpoena your email service provider to show that email was actually received and opened by the recipient.
Right.
Social workers know that. To say that they didn't get it, they're going to be hard pressed. But
Yeah.
it doesn't matter because you can bring them all into evidence and say, see, judge, here's the email address of the social worker. It was sent every week. She didn't get 24 emails. Wow. But it's more than 24 emails because you did it for just your individual counseling. You're doing it for your parenting class, your substance abuse class, your domestic violence class, your whatever class. You're sending out maybe 5-6 emails every week. Is it a lot of work? Yeah, it's a lot of work. Are your kids worth it? I hope so.
Hi, Cassandra. Oh my God, I haven't seen her so long. She just wanted to say hey. But I'm glad that you shared this with us. Are we gonna do a show tomorrow? Because I have a lot of questions. Actually, I've given you the questions I'm asking you is coming from parents, by the way, just FYI.
Is that Cassandra who used to be a host?
I think so, because I think that's
Is that
Jump-
Cassandra?
yeah.
Is that our Cassandra?
Yeah, I think it's my Cassandra, not your Cassandra.
Cassandra, is that you?
I
Okay, give me another question because I'm going to be leaving in a few minutes.
okay. Can the parents bring the emails with them, print them out, bring the emails with them in case their attorney doesn't show up and and there's no evidence or what have you? Can they bring the printout of the email, and if the judge says something, then they can bring it out and say, "Here, Your Honor, I have evidence with me right here."
Not only can they bring it, but if I were the attorney, I would list every email that I sent, all 24 for each of the service providers.
Yeah.
I would list them as exhibits. So if you have 24 to each service provider, and you have 5 service providers, that's 5 times 24 emails, and you list them as exhibits, and you provide every attorney and the judge a copy of all those emails.
Right.
If you provide a copy of those emails, I will bet you that at least 50 to 60% of the cases you will win without going to trial.
Makes sense.
I'm doing a criminal case for someone,
Mhm.
and we're in the process of writing a motion to dismiss the case. And he's asking me something completely off, not related to that. And I told him, hey, I'm working on the motion to dismiss. Wouldn't you like to have this case dismissed without going to trial?
Right.
And he thought about it and he says, yeah, that would be great. I said, well, let's focus on the motion to dismiss right now. So when you're doing this, focus on this. Don't call me up and ask me about suing the social worker. Once you get your kids back or you win this hearing, then we'll talk about that. But let's focus on this first.
Exactly. Okay, I guess that's it. You need to go to court now. Go get ready.
You can ask me one more.
Oh, damn. Okay. I wasn't expecting that. Okay. I have no questions, Your Honor, right now.
Okay. Well, here, I'm going to answer this question.
Okay.
From VJ. VJ on YouTube, what happens if emails are possibly scrubbed from Outlook and the judge refuses to read them? First of all, VJ, you've sent the emails to the social worker, your attorney, and the service provider. Now, how could they be scrubbed from all of those sources? Maybe they're scrubbed from your Outlook by mistake, but in order to protect yourself, send a copy to your Gmail account or your Hotmail account or your Yahoo account. Okay? Now, second, in my humble opinion, if the case is in California and you talk to your attorney if you're in another state, the judge can't refuse to read them. As a matter of fact, I would argue that the social worker would have to attach your emails to his or her 6-month report. They're relevant evidence. And if she didn't attach them, I would argue that her report is biased and should not be admitted into evidence.
Wow.
And if they haven't attached, your attorney can introduce them into evidence and you can testify about them one by one. And I don't think any judge is going to want to go through them one by one, but after a few, he or she will get the message about what's going on. You did every class, you progressed in every class on a weekly basis. I mean, it's not irrefutable evidence, but it's as close as you can get to it, right? You summarized every week what you learned, and it doesn't have to be a lot. It could be like 2 or 3 sentences. And then you list 2 or 3 ways how you implemented it or how you're going to implement it in your life.
It makes sense.
You can't beat that. Okay?
Yeah, it makes a whole lot of sense.
Okay. And you save it all, you save it all on your computer, and if you need to CC it to your Gmail and your Hotmail, you know, you'll have 5 copies, you know, and you print it out right before the hearing. Give it, you know, your attorney will already have copies. You bring them to court and then bow. You're ready to go.
And he said he's the, well, she or he said that they're the non-offending parent, and I hate that because it's happening to a lot of parents that they didn't know anything was going on, and they are saying that they failed to protect, and it makes
You know,
no
that's in my mind, that's BS. Non-offending parents are supposed to have the kid. Period. End of story. We can do a whole show on that.
Yes,
But
we can.
anyway, I'm on my way to court.
Love you too, Cassandra and Jimmy. Okay, go.
All right, I'll see everyone tomorrow at 6:30 a.m. for our office hours. Have a good day, everyone.
Okay.
I'm just so very thankful again to have them and to have found them, and I would recommend them to anybody that's going through this, because it's hard and you're gonna make mistakes, and the mistakes can make the situation worse, but they come in and they just know what they're doing. And again, to have his number at your dispense, like no other attorney does that, and they get back to you right away, and again, comfort you, fight for you. They just reassure you, and when you're going, like I said, going through this nightmare. And I'm so blessed to have found them.